Look at this. Wow, it's almost like a town meeting. Almost, not quite. Too soon. No, we just had the town meeting. You missed it. So my name's Julie Freilich. Can everyone hear me? Yes. Okay, thank you. That's not why I'm here at all. I am actually with the group that we call BLING, which most of you probably know, but it stands for Building Livability in New Gloucester / Gray. We welcome Gray people too. And we've been having a series of presentations. Last time we had one on AI. We've also had one on decluttering. And next month we're going to have one on dementia care. And so this week we're very excited to have one on estate planning. Just to give you a little background as well, among other things that we do in addition to these presentations is we have two wonderful community connectors who will raise their hands in the back, Lori and Sheila. And they basically are available to help connect people to services, resources, answer questions. You know, having a problem with X, Y, or Z, they're sort of our on-the-ground people to help connect people to services if you need it. But we also hold a weekly tea/coffee in New Gloucester and Gray on Thursdays. We're going to be moving to our new rec center in June, and they're going to have coffee every day from 9 to 11. But our community connectors will still be there on Thursday mornings, and we're still trying to figure out what we're going to do in the afternoons or whether we're just going to group all of Gray and New Gloucester together. But we're very excited about that as well. We also realized that I didn't print out enough copies, but we're trying to produce a hard copy sort of summary of a calendar for a month, because there's a lot of things going on, not just with us, but with the rec program, the library, the church. And so we're just trying to have things sort of in one space, if you can read it, but if not, get out your magnifying glass. And also just a plug, because we also run a volunteer transportation program, which is fantastic. We take people to medical and dental appointments within about a 30-mile radius, but we're also always looking for volunteer drivers. And it's the kind of thing where you don't have to sign up like, oh, I got to do this every week at this time. You'll get a notice like at the beginning of the month, and you can say, oh, I'm available that day. It looks like they need a driver. So it's very flexible. You don't have to feel like you're locked into, you know, a full-time volunteer job, if you would. And then just for fun, we put a whole list of decluttering resources if you're looking to get stuff out of your house, which we all are this time of year. But with no further ado, we're very excited to have two folks who were here last year. I'm going to say Greta and Tracy, okay, and you can add in the last names and other things. Who are going to give us an overview of estate planning, which was just hugely successful and helpful last year, and I see many people here again. But I'm going to let them do the further introductions and just get things going. There you go. Oh, but you can take the mic, because I've talked enough, and I'm going to leave.
Thank you so much, Julie, and thank you, BLING, for bringing us back. We always love coming to New Gloucester. I got to be part of BLING at the very beginning, and it was really wonderful. It was a really great part of my time in New Gloucester, where we've moved away now, but I'm so excited that BLING is doing so many great things. My name is Greta Atchinson. I am an estate planning and elder law attorney at Landman Rain Nelson Reed, and I'm here with my colleague Tracy Ferland, who is also an estate planning and elder law attorney at Landman Rain Nelson Reed. We have an office in Falmouth. We also have an office in Bridgeton. You guys are literally halfway between my house and the Bridgeton office, but most people, I mean, the Falmouth office is, 25 minutes away or so, so it's pretty close. We specialize in estate planning and elder law. We also have a real estate and a business department, but what we do is estate planning and elder law, and we are here today to talk about the estate planning essentials, and it's not just for people who are 65 and over. These estate planning essentials, and we're gonna start out with the most important ones, you'll hear from Tracy on those. Those documents are essential for everyone over the age of 18. So we're gonna talk about that. So a lot of people in your lives could benefit from having some estate planning. So we are just gonna kick off.
Okay. All right, hello, can you hear me?
Yes.
Wonderful. My name is Tracy Ferland, and I have been with Lamb and Rain for about 4 years now. As Greta said, I practice in estate planning. We do asset protection planning, elder law, and previous to working with Lamb and Rain Nelson Reed, I was up in Bangor, my hometown, where I practiced for a little bit more than 10 years before that. So it's very nice to be here with you all. Thank you all for coming. And as Greta said, I'm going to be talking about a couple of very important documents that I think sometimes are overlooked in estate planning. I think when we talk about estate planning, what most people's minds go to is, well, do I need a will? Do I need a trust? Those are sort of the things that pop into people's minds. And what I'm going to talk to you about here today, without messing with the microphone, is powers of attorney, a financial power of attorney and a healthcare power of attorney. So as Greta said, these are essential estate planning documents. I recommend these to almost every single client that I have walk through the door, with very, very limited exceptions, which are usually just the people who have them already and they're recent and they still match their wishes. So very important documents. With respect to the financial power of attorney, what is it? This is a document where you can name somebody that you trust to stand in your shoes for financial matters. So you can make these documents as broad or as narrow as you wish, but usually these documents are very broad, because if you need help, it's very difficult to anticipate what you might need, right? And so we like these documents, as long as we've named somebody that we completely trust, we like these documents to be very broad so that that person that you've named can meet your needs regardless of what they might be down the road. So what sorts of things might that be? The power to pay your bills, the power to deposit checks on your behalf, the power to buy and sell on your behalf. This would apply to your real estate, to your liquid assets, bank accounts, investment accounts, retirement accounts, things like that, changing beneficiaries, all of those types of things. These documents also include some broader powers if you choose, and those are the powers to make trusts and the powers to make gifts. And I'm not going to go too far down the rabbit hole here with asset protection. Greta and I could host a whole week of seminars on asset protection. But all I will say today, which is the most important thing, is those broad gifting powers are usually the powers that are essential to protect your assets if you find yourself in a circumstance where you may be looking at depleting your estate on long-term care needs. Those are the powers that allow us to have the tools in our toolbox to protect the assets for you. So these documents can be effective right away. They can be effective only upon your incapacity. Typically with folks who come into our office, many of the clients that I see make these documents effective immediately because they have named somebody that they 100% trust, and I like it when they say, I 1000% trust this person. That makes me feel really good, and I will leave the mic alone. That makes me feel really good. So if you 1000% trust the person, what making that document immediately effective does is it cuts out a layer of red tape for them. So if you're at a point where you need help, you have lost capacity, they need to step in to help you, they can do that right away instead of having to go to a doctor, get a letter from the doctor establishing your incapacity. Something else I'll mention just briefly is sometimes when individuals who have executed this type of document have lost their capacity, sometimes it's due to dementia diagnosis. And sometimes with a dementia diagnosis, there's some paranoia that comes along with that. And so even though in a moment of clarity, the person may have signed this this document and said, I trust this person, if the document is effective only upon incapacity, and in that moment where they need help, some of that paranoia is presenting itself, and they say, well, I don't want to submit to an examination so my doctor can sign off on my incapacity. That person that they trusted in their moment of clarity has to go through the court process to establish authority anyway. So those are the sorts of conversations we have when we talk people through whether to make these documents immediately effective or effective only upon incapacity. It's a personal decision, but those are sort of the factors that we like to talk through with people in making that decision. These documents, we recommend them for everybody, as Greta said, regardless of age, regardless of health condition, regardless of financial status. And part of the reason for that is these documents are crucial if a person has lost capacity and needs help managing their finances, but they also come in really handy for other folks. So for example, my husband is my agent under a power of attorney. If I want something with my finances managed, if I want to change a beneficiary, and if I don't feel like doing it myself because I'm busy, I can say, John, can you go take care of this for me? And even though I have capacity, if I don't want to, if I don't feel like it, I can have somebody else do that for me, and that can come in really handy. Another situation is college-age students. Often they need some help with financial management, but also they're going to class, they're hanging out with friends, and maybe they would prefer for their parental person to help them with that. So these documents are handy for all sorts of people in all sorts of stages of life. So that's one of the reasons that we call these an essential estate planning document. We've discussed the powers that they include and asset protection. I want to talk a little bit about who to choose as a power of attorney, an agent under one of these documents. Sometimes it is a family member. Sometimes it is a friend or another trusted person in your life. Sometimes it is a professional fiduciary. There are people in the community who, as part of their work, they serve in this role for different people. Sometimes those are attorneys or other type of fiduciary individuals. The absolute most important thing, as I mentioned a moment ago, is you have to trust them 100% because these documents are very, very powerful. And if a person who is named in these documents abuses their power, right? We hate to think about it, but if that were to happen, there is a court process by which to remedy the wrong that has happened, but it is often going through that court process it takes a long time to get through that court process. Lawyers need to be hired to defend your rights. And I used to be in trial work, and we like to say in trial work, even if 100% of the facts are in your favor, 100% of the law is in your favor, you got about a 75% chance of winning at a trial because there's so much uncertainty when it comes to trial work like that. So how we like to think about who we choose is, sure, there is a court process to remedy any wrongs, but we want to right now, today, when we're making the decision for who to choose, we want to choose the person that we 100% trust, not 99, not 98, but 100, right? So that is the very most important thing I can drive home for you today when it comes to financial powers of attorney. If you are choosing a trusted loved one, a family member, a spouse often might serve in this role, or a trusted friend, it's good for them to have some organization skills because part of what their job will be is to keep documentation of everything they've done, to keep receipts, to keep good notes, to keep bank statements, anything that they've done, they want to be able to have that organized so that later on, if they need to establish what they did and why on your behalf, they'll be able to have organized documentation to show what they did, why they did it. So those are qualities that are good to have in a person that you name under a document like this. The person that you name, they are under the highest level level of legal duty to do the right thing for you. We call that fiduciary duty. You've heard me use that term a couple times. And they have the highest level of fiduciary duty to you as the person who has signed this document. They have to use the utmost care and diligence. They have to do their very best, very most diligent work, and they have to be loyal to you 1,000%. So those are very, very high duties. But like I mentioned a moment ago, we want to name somebody that we 100% trust to carry out those duties. So you can revoke these documents anytime you want once you've put one in place. If you change your mind, if your relationship with whoever you've named changes, if there's somebody else in your life who for whatever reason might be better in that role, you can revoke these and sign a new one as long as you have capacity. And by that I mean the power to understand what these documents do, the consequences of signing one, and who you're naming and what the implications of a document like this is. As long as you can do all of those things, you can revoke and sign a new one of these. So that is good to know. What happens if you don't have one of these in place, right? What's the big deal? Why are we so concerned about that? If you don't have a financial power of attorney in place and you need help with financial management, what your loved one will need to do, or your family member will need to do, is go to the probate court and file paperwork for what's called conservatorship. There is very detailed paperwork that needs to go out. There is notice that needs to be sent to a collection of people who are the people that the judge would expect would want to know about this in your life. So certain family members, certain people who have been involved in your life. And then at the end of the day, it is the judge making the decision on who's going to help you. So they may not know all of the things that you know. You know, maybe for whatever reason you don't really trust, maybe there's an adult child that you don't really trust, but that's the person who has filed to be your conservator. The judge may appoint that person, and the person that gets appointed may not be the person that you would have chosen yourself. And again, this will have been after a time-consuming process that may have taken months to get you the help that you need. So there are several reasons why it's good to have these decisions made, your decisions made at the outset. A couple of other things about conservatorship. Even if somebody gets named who is the person who maybe you would have chosen, the conservatorship process puts an extra burden on them. They have to have a continuing reporting relationship with the court so that the judge knows from year to year that they are doing the right thing for you. They need to file accountings. And the other thing to keep in mind, if the conservatorship process is necessary, let's say you are in a position where you are looking at, maybe an assisted living situation or a nursing home situation, and maybe the fear is that those assets are going to be depleted on that type of long-term care. Through the conservatorship process, there are fewer options available to you for asset protection than there would have been had there been a financial power of attorney in place. So that's another reason why conservatorship, it's there if needed, but financial power of attorney, putting that in place that reflects all of your specific wishes, that's really the best thing in these types of situations. One other thing that I would mention about financial powers of attorney, which will dovetail in with medical powers of attorney, and I want to be conscious of time as well, is that families fight, right? Even families who, parents may have come in and said, my family, we all love each other so much, everything is harmonious. The stress of a medical condition, the stress of some sort, a stroke, a heart attack, whatever event precipitated this need for help, the stress of that by itself can change how people react with each other. And having a document like this in place where you yourself have said, this is what I want, this is what I authorize, this is the person I want in this chair, that says to the rest of the family, this is what Barbara wanted. This is what Doug wanted. And so if there's any question about, well, Mom would have wanted me, or Granddad would have wanted me to serve in that role, or, my friend always told me that they would want me to do that. This document says for sure, this is who Doug wanted, this is who Barbara wanted, this is who your friend wanted. And that eases those tensions. It cuts down on that stress during what is already an incredibly stressful time for those loved ones. One more thing I will mention about financial powers of attorney before we move on to medical powers of attorney is a couple alternatives to, I shouldn't call them alternatives, a couple of other ways that are not replacements for financial powers of attorney, but other ways that somebody might be able to help you with finances. One of which is naming a representative payee for Social Security purposes. I believe that that's available for designation on the Social Security website, and I believe that there's a way to do that in advance as well. Am I right about that, Greta?
Yes.
There, okay. So that's one thing to consider. Another thing that people come to our office a lot to say is, well, can't I just add my son or my daughter or my trusted loved one? Can't I just add them as a joint owner on all of my accounts? And I understand why that feels like a good, easy solution, and it is easy, but I would just offer a couple of notes of caution. First of all, that gives that person authority over those accounts only. It does not give them the other powers that are encompassed in the financial power of attorney. So signing contracts on your behalf, buying and selling real estate, things like that. A joint owner cannot necessarily do everything that they would need to do without having that financial power of attorney in place. It's just the power over that one account, that one asset, right? The other thing to keep in mind about that is by making someone a joint owner on that asset, you are making them a joint owner on that asset, which means that they become an owner for purposes of if they're going through a divorce, if they have creditor issues, if they make a bad decision, all of those things, as a joint owner, that asset becomes vulnerable to all of their life circumstances. So if they get in a bad car crash, they have a money judgment against them. The judge in that case says, okay, you have to satisfy this money judgment. Tell me about all of your assets. Guess what? That asset, that joint account, that's in the list, right? And you may not have intended that. So that's one thing to keep in the back of your mind. The other thing about joint ownership of bank accounts is that in a typical situation, that account would pass to the joint owner at death. So if you pass and the account becomes the joint owner's asset, sometimes that might align with your estate plan. But let's say you have 3 kids, Anna and Billy and Kathy. And boy, you love Billy and Kathy, but Anna, she's the organized one. She's the one who knows how to handle the documents, and she lives locally, and that's why you chose her, right? But if she is the joint owner on that account, maybe your will says, I want my estate in equal shares to Anna and Billy and Kathy, but at your death, the bank is going to give that entire asset just to Anna. And sometimes people in Anna's position, they say, okay, I'm going to split this with Billy and Kathy. Other times people in that position say, well, this is legally mine. And I think mom or dad or auntie would have wanted me to have this. Or maybe they say, well, gosh, I put in all of this work on behalf of mom or dad or auntie. I deserve this money, right? And so that can create stress, that can create family division, and that can lead to an outcome that you did not intend, right? So again, sometimes that might be one piece of a plan that may work for your particular situation, but lots of reasons to think through why it might not be a perfect solution for what you might want. So those are my comments on financial powers of attorney. Should we wait until the end for questions, do you think?
Sure. Oh, okay.
When you were going over, I'm trying to remember, was a trust the way to go to about, say, the life things that popped up, like a divorce or something like that. Which, if somebody, you know, your parents or whatever gave you property or whatever, or something of value, would that be subject to the divorce or whatever? And I'm thinking you said basically yes, it becomes part of your property. I'm making stuff up.
No, that's okay. I'm just not sure I understand. Do you understand what he's getting at there?
Sure.
Sorry, go ahead. Yes,
So,
go right ahead.
I was just asking.
Yeah, so as far as whether like a power of attorney, the question we're going to talk about trusts and wills, and like creditor protection in trusts is a different thing. If you have a co-owner on an account, if you've named a co-owner, one of your kids, or your parent named you a co-owner, and then you go through a divorce, particularly if they're going through a divorce in Massachusetts, because the laws are different there, or there's a claim of creditor, or there's a lawsuit, if you're a co-owner, it's not protected. But trusts can be protective, not all are, and we're going to get into trusts a little bit more later on.
That's what I was hinting towards, protecting what you were trying to protect originally before that life issue came up.
Yep. So Greta will get into a little bit of that in a little bit.
Okay.
Yep. Okay.
Just that.
So that's okay. Do we have until just 2?
Yes.
Okay.
It's okay.
So I am going to go quickly through this next section about healthcare powers of attorney. So similar to a financial power of attorney, in a healthcare power of attorney, what you're doing is you are choosing somebody else to make care decisions, treatment decisions on your behalf. And I want to just talk a little bit about a few terms, because we hear a lot of terms being thrown around that are sort of adjacent to this idea. A healthcare power of attorney is the piece of, and if your doctor has given you one of these, this is what we're talking about right now, healthcare advance directive. So when we talk about a healthcare power of attorney, that's the part of the document where you are naming a person that you trust to serve in this role for you, to make care decisions for you, right? And you can name one person, you can name 2 people to work together. Often we recommend that you name some backup individuals as well, in case your first choice couldn't serve. If you have some backups, we recommend that as well. And that's the same with the financial power of attorney as well. A living will, you may have heard that term. That's the part of the document where you are expressing your wishes for end-of-life decisions. So things like, if I was being kept alive by machines and my doctor concluded that treatment wasn't going to make me better and I am not likely to regain consciousness, what do I want to happen in those circumstances? Those types of end-of-life decisions are included in what's called the living will. The Healthcare Advance Directive is kind of a larger document that usually has a healthcare power of attorney in it and a living will in it, and it usually has some other information in it as well, including what are your preferences for cremation versus burial? What are your preferences for organ donation? What are your preferences for any special wishes if you were in hospice care? Some people say, well, if I was in hospice care, I want to listen to Elvis. I want my favorite book read to me, things like that. You can include that in documents in a Healthcare Advance Directive document. There's a couple other terms. People ask about DNR. That's a do not resuscitate order. That is a type of document that I would say, go talk to your doctor about that. That is a document that directs your care providers not to perform CPR on you. That's a conversation to have with your medical provider. Similarly, there's another document that you may hear from time to time called a POLST, P-O-L-S-T. It's a more detailed document that includes wishes about, again, CPR, intubation, assisted feeding, tube feeding, things like that. And again, that is a document where we would invite you to talk to your doctor about that to see if that is an appropriate document for you, because the DNR and the POLST documents, those usually are signed by people in a very specific type of physical condition, and that's not something that a lawyer can or should advise you about. So that's a conversation to have with a doctor. So for your healthcare advance directives, we talked a little bit about what is in them. We're naming a person, and we are expressing some wishes for end-of-life care, burial, organ donation, things like that. Who should you choose for a document like this to be your, we call them agents, to be your agent? Unlike the financial power of attorney, where I said to you, it's got to be somebody you 100% trust, and it would be good if they were organized, good with documents, things like that. For this document, we still want somebody that you 1000% trust, but this is somebody that should be very familiar with you and your wishes and your values. They should know how you feel about end-of-life care. They should know how you feel about different types of treatments. They should be familiar with your heart in that way. And also, it has to be somebody who will respect your wishes and your values in that way, right? So that's somebody that is good to name. Usually, like I said, usually that's a loved one, a family member, maybe multiple family members working together. That's a possibility as well. And why do you want one of these? If you don't have one of these in place, obviously the family division aspect that we talked about a moment ago, multiply that by 500, because these decisions, it's not about money, it's about care, and those can be more emotional decisions. And so to be clear about what you would have wanted will cut off any the fight or it helps to cut off the fight between family members who may have different understandings about what your values are or what you may have wanted. So cutting down on that family tension. Again, these tend to be very stressful times on loved ones. To be clear about your wishes are. And also, similarly to the financial power of attorney, if you don't have a medical power of attorney in place and healthcare decisions ongoing need to be made for you, again, in an ongoing way, and a judge needs to get involved to choose somebody, that's called a guardianship process. And again, the person that the judge chooses may not be the same person you would want to serve in that role. That's a time-consuming process. It sometimes takes months. If there are decisions that need to be made in the near term about your treatment and care, and you don't have one of these documents in place, there is a statute that we have, a default statute, that tells doctors if there's no healthcare advance directive to look to see what this person would have wanted, we have this sort of default list, hierarchy of family members and loved ones who, just by sort of common sense and how many family relationships go, this is sort of who we would assume you would want to serve. So we assume that you would want your spouse to serve. We would assume that maybe you would want your adult children to serve. So there's a statute with a hierarchy there. But again, that can be confusing for family members to navigate that statute and figure out who's in charge. And it can create division because the statute might say that Billy's in charge, but Mom may always have told Anna, I really want you to be my person if this were to come to pass. And those fights can be emotional and they can really be divisive among a family. Again, we talked about what is in these documents. We talked about what would happen if you don't have them and who you picked. The last thing I'm going to mention before I hand the mic over to Greta is that these documents have to be done while you have capacity. So a very sad meeting that sometimes happens with us is we may have a loved one come into us and say, I have a mom, a dad, an uncle, a trusted friend who is declining. They're really struggling. They're having trouble. They need help. Can you do some documents for them? Can you put in place a financial power of attorney? Can you put in place a healthcare power of attorney for them so we can help them? And we may meet with that person and we may not be able to conclude that they have the cognitive capacity to put together those documents. Maybe that person can't identify for me who their family is. Maybe they've gotten to such a point that they can't identify their family, or they can't articulate that they understand the consequences of signing these documents, that's when we have to give the bad news to the very well-intentioned, trusted loved one that, I'm so sorry, that ship has sailed. That's something we may have been able to do a year ago, 2 years ago, maybe even 6 months ago, but today, can't do it. So once a person is incapacitated, these easier options are off the table, so that's a good reason for everyone to get these in place right away. So I'm going to hand the mic over to Greta.
Sure, and I am just touching on a couple of things. Yes, you had a question?
Question about the healthcare. So if, in the state of Maine, if you have, when someone has capacity, enacted a healthcare power of attorney, did I hear you right that you said the living will is part of that document?
So the question is, in the state of Maine, if you have a healthcare advance directive, is the living will part of it? And yes, and this is, so we draft healthcare advance directives that look different than this, but this is what the Maine Hospital Association, Maine Health, Maine Physicians Association has gotten together. This is the form that they hand out. This has in it a healthcare power of attorney and a living will. The older documents, I would say pre-2004, maybe 2009, those documents were separated sometimes, the healthcare power of attorney and the living will. So they are still valid though if they have not been revoked, if you haven't signed a new document. But generally now, when someone is signing a healthcare advance directive, they're signing the power of attorney, which is the part 1, and also the living will piece, which is the part 2.
But now, when you had capacity, you created this power of attorney for health and did a living will, and then you became incapacitated, in the state of Maine, is it binding, the living will, advance directive, your wishes, if the healthcare power of attorney says, no, they told me they changed their mind, or I don't want to do what they said? Who gets to decide that?
So first off, if you can communicate your wishes, even if it's not taking a formal determination of capacity for you to revoke part or change your mind or alter your healthcare advance directive. So if you are able to voice your wishes, there is a good chance that those wishes will be carried out. As far as whether it is binding.
So, former litigator speaking, hospitals they are going to want to avoid a lawsuit, and they take a practical approach often to these types of situations. I can't tell you 100% what the outcome would be, but the intent when we sign and execute these documents is that the family will follow these wishes, and that the hospital will and their legal team will follow these wishes. With that said, when there's litigation afoot, and certainly if an entire family is wanting to do something different, that's something where I certainly can't guarantee what the outcome would be in this case, but the intent is that these would be legally binding documents. Yes.
We're with Maine Health, and they have their own healthcare directive, and other doctors' offices have theirs. Do you need to do those in addition to what you're showing up there in the Maine official website, or does that supersede?
No, they're.
Oh, sorry, holding the mic. So you do not need to do multiple versions of the same document. Typically, the documents include the same information in them. If you have already, for example, if you've done one with an attorney's office and it includes all of your wishes, and if those are still your wishes, if the specific hospital has their own form, you don't need to do their form.
One more essential document that's a healthcare document that's not on here, we don't have it as a handout, because it's not as common in Maine, but and particularly if you have kiddos or young adults in your life who are headed off to school and outside of Maine, you're probably going to want a HIPAA authorization. So as part of our Healthcare Advance Directive, there's an authorization to release your health information to your agent. This is a separate document, a HIPAA authorization. It's a separate document that lists out the people not decision making, the people that can receive health information about that person who's over 18. And a reason that that is so important, particularly if you have young adults in your life, is that if there is a medical issue and you have an 18 or 19-year-old in your life, they're technically an adult. Even though they don't feel like an adult to you, they're technically an adult. And so whether it's the school health center, whether it's a hospital, they can't talk to you if there isn't authorization. If they talk to your kid and your kid authorizes it, that's fine. But unfortunately, there are circumstances where that child cannot talk, and so the information cannot be released. And so a HIPAA authorization, it's under federal law, and it's about health privacy. And it's an authorization, and you can make a list of people who can receive that person's information. It gets signed and notarized, and that is a really important document, particularly if you have someone who you might need to get their health information, and particularly if they are traveling. Now, for the Healthcare Advance Directive and the power of attorney, those are creatures of Maine statute, but they are also recognized all over the country. So if you spend time outside of Maine, again, if you have those young adults in your life that are maybe they're deployed or they're going to school, outside of Maine, those documents will be recognized. You don't need a Massachusetts document just because you're going to go to Massachusetts. Yes.
Just to clarify, Greta, so what you're saying is, if you have the healthcare power of attorney for your young adult child, if they were incapacitated, you would be authorized to make healthcare decisions for them. But if they're not incapacitated or don't meet that degree, without also having the HIPAA permission, you wouldn't necessarily be able to help them with any healthcare related stuff or get information about their records if they didn't directly get it.
Yes, so Rachel's question was just that if you had a young adult in your life and they had a Healthcare Advance Directive and they had authorized you to make decisions, but only if they were incapacitated, you wouldn't automatically be able to get healthcare information. Now, there is a checkbox on the Healthcare Advance Directive that authorizes immediate release of healthcare information, so it doesn't wait for incapacity. But if that box got missed, or they just decided, oh no, I don't want my mom to know everything, then it creates a situation where they're not incapacitated, but they're not available to authorize you to get information, and your parent needs to know. So it happened in my family. My sister at 18 had a car accident, and she was unconscious, and this town rescue, I grew up in Naples, the town rescue called my mom because my little sister was in the car too. And they told her about my little sister. And my mom said, what about my eldest? And they said, oh, I'm sorry, we can't tell you anything. And so as a mom, she just thought, oh no, the worst. And so she had to go to the hospital and see that they were both there, but my sister was in and out of consciousness because she was over 18. And so that would not have happened if they had magically known she had a HIPAA, which she didn't, but now she does. So it's an important document to have.
Could I add
Yes.
that my husband's brother-in-law had a stroke in Texas, and because there was no HIPAA, so it doesn't matter whether it's a young kid.
Mm-hmm. You're right.
75.
Yes.
And Maine doctors could not talk to the Texas doctors. So the HIPAA is really
HIPAA is really important because HIPAA makes it a felony to release your health information without your consent. And for hospitals and medical groups, it is $75,000 for an inadvertent disclosure of your health information. And it comes up in really big dramatic ways, like when high school or when college basketball players get injured and they're at a hospital and then there's a leak about their condition. That's a HIPAA violation, and somebody got fired and fined for that. But in our everyday life, the way that we encounter it is if someone is injured, if somebody is needing medical care and you need information about that care, if they're an adult, if there's no HIPAA, there's no authorization to release the information to you. Yes?
I got a question for you. in order to bring prosecution, if you will, you're gonna have a complaint from the original victim.
So I don't know about that. That's not my area. So the question was about prosecution on HIPAA authorizations. That's really, so there are health and privacy attorneys, and that is all they do. Not all they do. They do a lot more, but that's a lot of what they do, and so I cannot speak to that.
Right.
Okay, so I'm gonna, yes,
Just a question, I hear the healthcare power of attorney and the medical power of attorney, same thing.
So here's the thing about estate planning. We create a lot of terms and acronyms for really similar things. And so the healthcare power of attorney, the healthcare advance directive, the living will, the healthcare, you said one more.
The
Medical power of attorney.
But I'm a medical POA for my mother-in-law. And
Yes.
Oh, I'm good.
Yeah, and the other thing is that in Massachusetts, it's called something different. In Florida, it's called something different. They're all the same role. It's just we're using different terms. Okay, so I'm gonna jump into wills. So a will is a document that you create during your lifetime that you put in place who you would want to pass your assets on to, who you want in charge of that, and how those assets should flow. I mean, that is simply what a will is. It is a written document you create during life that is not effective until you pass away. A will takes probate to be effective. So if you are relying on a will, you are going through probate, if that is the way you are passing your estate. A lot of people talk about, oh, probate's so expensive, probate takes so long. Probate in Massachusetts and New York is so expensive and takes so long. Probate in Maine, it still costs money, but it does not take as long as it does in other places. So Maine is much more of a will-based jurisdiction than other places. So if you have friends and family from Massachusetts, they're talking about their trust. I practiced in Massachusetts for the first 11 years of my career. It was very much a trust-based jurisdiction because probate took so long, it was so invasive, it cost so much money. A trust was easier because you got to avoid, if you had funded your trust, which we're going to get into, you could avoid probate. But in Maine, it's much more a will-based jurisdiction. So someone creates a will, they put their wishes down. Now, most people that we see are putting their wishes down and we're typing it in. And then when they sign, after they review it, we're signing it together with 2 witnesses and a notary. That's the formalities of which you need to sign a will. But in Maine, under statute, you can also have what's called a holographic will. I do not recommend these because not only because I'm an estate planning attorney, but also because there are many pitfalls. But a holographic will is in your own hand, you writing out your wishes. And that, because it is in your own hand, that does not require the same formalities necessarily to be a valid instrument. So we see, and particularly from spring of 2020, updates to wills. And they are handwritten. And they're just signed. They're not notarized necessarily because they are handwritten. They're in your hand. Now those holographic instruments can be witnessed and notarized, and that's the formalities piece. But a will can be effective if it names a personal representative. So that's also used to be known as the executor. So it's a written document that names a fiduciary, to borrow one of Tracy's terms, names a fiduciary, someone who is in charge of marshaling all of the assets, paying the bills, paying debts and expenses, going through the probate process, which is why you get appointed to pay those debts and expenses, to make those distributions, and then to close down the probate itself. So the probate process, we don't have to get into it today. A will does guarantee probate. For assets to pass via a will, for a personal representative to have the authority to pass assets via a will, that requires the probate process, which is public. So any of us could go to mainprobate.net and search some wills, and we would see wills of others. So sometimes people want to avoid probate. We're going to talk more about that if we've got the time, but a will is an essential document because it is your ability to say, this is what I want to pass on, these are the people I'm putting in charge, and here are some more terms, whether you want them to be paid, whether you want there to be a trust created within your will. There are many opportunities for customizing that will, but since we're running short on time, I'm just gonna give you kind of the quick and dirty what a will is. If you do not have a will, there is a statute that makes a guess at what you would want your estate to look like. So based on your family situation, who would inherit from you and who would have the priority to get appointed by the probate court to make distributions and to pay taxes and expenses. And maybe that aligns with what your wishes are, but maybe it does not. And increasingly we meet with more people who have families that are less, who have the found family, or they are including people that are not necessarily close blood relations. And so those people would be excluded from the statute. And so having your own will, you get to make your choices and you get to decide who you leave assets to and who is in charge of getting those assets to those people, who is in charge of paying your final taxes, paying debts and expenses, transferring assets. Wills that are valid when you sign them in Maine as Maine residents are valid if you move away for a short time or if you're traveling. A holographic will that you make when you live in Maine is valid even if you move to Massachusetts where holographic wills are not valid. You cannot be a Mass resident and create a holographic will here and expect it to stand up. But you can be a Maine resident and you can move with a valid document and it will continue to be valid even if you move away and it's not, their law does not contemplate it in the same way. As far as how often you want to update your will, and this is also true of how often you want to update your healthcare advance directive or your financial durable power of attorney, you want to update your documents when something about them changes. It's not a hard and fast rule like every 5 years. No, it can be helpful to check in every 5 years or so to see how things have changed or not changed. But if you have not changed the person who would make healthcare or financial decisions for you, the person that would inherit from you, the person that you would put in charge of paying those debts and expenses, being that fiduciary, if those have not changed just because time has passed, it does not require an update of the document. Okay, so we're going to talk very briefly about a revocable trust. That is true. Very, very briefly about a revocable trust. So trusts come in many different ways, in many different forms. A revocable trust is the most common. It is a trust where you are in complete control of every part of it. You create this trust. You are quite often the trustee, so you're the manager of the trust, and you can make any changes to the trust. That's the revocable nature. You can amend it, you can make changes, you can tinker during your lifetime. What does a revocable trust do? It is tax neutral. So as far as the IRS is concerned, it is the same as you holding the asset. But it creates a framework, like a will, it creates a framework for who manages the assets, who receives the assets, both during any period of disability for you and also after your death. So a trust is effective when you sign it. It's only really useful to you when you actually put assets into it, like changing bank accounts into it, deeding your house into it. That's how a trust can actually avoid probate, because the trust creates a plan for assets to flow to beneficiaries. The will does the same thing, but is only effective after you pass away. The trust actually can begin investing assets the way that you talk about them being invested in your document. It can also make distributions. If you become incapacitated and you had always sent money to one of your kids or sent money to a sibling, your trust would have terms in there that would acknowledge that you had done that, and that you wish to continue to do that as long as your finances allowed. So even though it's not strictly for your benefit, your trust would make those special provisions within it. So a trust is highly, highly customized. A trust is also private. So if you have a trust, that trust is not getting filed with the probate court unless there's a big disagreement. That trust is not getting filed with the probate court in the same way that the will would. And so this is able to be a more private document. One very popular reason for having a trust is that you might have property in Maine and you might have property somewhere else. I'm talking somewhere else in the US because Canada's different. But if you have property here in Maine and you also have property maybe in Florida, North Carolina, Arizona, if you like warmer weather, real property is probated where it lays. And so if you had a will and you had a house here in Maine and a house in Florida, you would be doing a Maine probate and a Florida probate. And Florida is one of those jurisdictions I didn't mention where probate can be really long and really expensive. So it's very popular if you have property in multiple jurisdictions to have a trust. You might not want a trust if you want to maintain complete control and access. If you don't like the idea of there being a framework where someone else would automatically be able to take over. You might not want a trust if you have a spouse who has long-term care needs potentially in the future. There are reasons that a will could pass assets in a more protective manner for you. So a will with special needs trust that's created under the will rather than a standalone trust is very popular in that circumstance. And so a revocable trust, it's not right for everybody. It also takes a lot of work. Not only, the attorney handles establishing it, but often you're on your own for getting the assets in and funding the trust. And that means changing bank accounts, changing investment accounts, and with the investment accounts, they make you reopen the investment account, so it's a lot of paperwork. It does not mean that your retirement accounts are going in, because they are not going in during your lifetime. A change of title on retirement accounts is a taxable event, so you are not doing that. But for revocable trusts, sometimes people don't want to do the work, and that's okay. And sometimes probate wouldn't be that bad, and that's okay. A trust, there's no one size fits all for estate planning. Okay, so there are some will alternatives we're going to talk about just briefly. The first is the transfer on death deed. So in 2019, Maine passed a statute about the transfer on death deed. And it's actually in the statutes. If you're law nerds like us, it's interesting. It's with the wills in the statutes and not with the deeds. So it is a will alternative. It means there's a lower capacity to be able to sign a transfer on death deed because you're treated as though you are signing a will as far as the capacity required. A transfer on death deed is a revocable document that you can sign at any point during your life, and you appoint, it's putting a beneficiary on your property. You can appoint people who would inherit your property at your passing. It is an immediate transfer of your property. It is probate free. The property passes subject to all liens and encumbrances, which means if you have been in a nursing home for decades and Maine Care has been paying the tab, there will still be a Maine Care estate recovery claim, even though there's no probate. If there's a mortgage, the mortgage would still pass with the property. You don't get it free of the mortgage, but you would be able to appoint the next owners of the property. It's revocable, which means it is fully your decision whether or not you want to keep it going, and at any point you can decide to sell your property, or you can revoke that transfer on death deed, or you can do a new transfer on death deed with somebody else on as beneficiaries. Those beneficiaries, when they inherit, they have a difficult time selling immediately. So if you need to sell the property immediately, a revocable trust is going to be friendlier to an immediate sale than a transfer on death deed. And the reason for that is that Maine has a 9-month creditor period statute that says that if people pass away, Creditors have 9 months, if there's no probate, they have 9 months to submit their claim to the personal representative or the family, you know, the next of kin, the person who's in charge. They have 9 months to submit that claim. And if they submit outside of that 9-month period, they're barred. It's a shorter period if you do file for probate, which is sometimes done for that reason. But during that 9-month period, title companies do not want to have creditors approaching them saying, wait a minute, you sold this property 3 weeks ago and we have a claim for $22,000 for a credit card that wasn't paid. We need to be paid. So generally, the title companies would like you to wait at least 9 months to sell the property. So while you can pass the title immediately, you do not necessarily have the ability, or it's not an easy road to sell immediately. Additionally, we saw in other jurisdictions that property insurance can be a little bit tricky with transfer on death deeds. So in Maine, there's an automatic extension of 90 days. So after someone passes away, if they have a transfer on death deed, their property tax extends, they're like, not property tax, insurance, property insurance, not tax, sorry. The property insurance extends 90 days automatically. But after that 90-day point, the new owner has to get the insurance. And so you really do need to let people know, hey, I'm creating this transfer on death deed. I plan to pass this property to you, and you're gonna need to get insurance, but you're not the owner right now, so the insurance is still in my name, but when I pass away, you need to act pretty quickly and get the insurance. And particularly, it's gonna be a new insurer, and they're gonna come out and do an inspection, and they might say, oh, you need to work, the deck's not safe, the trees need to come down, so you do need to be prepared. Putting beneficiary designations on accounts is a way for accounts to have a contract that determines who inherits that account. It's common on life insurance, it's common on retirement accounts, it's common on CDs, and other accounts will allow you to put beneficiary designations on those. The beneficiary designations do not go through probate unless you are designating the estate as the beneficiary. But that beneficiary designation allows you to pass assets to others without having to go through probate. And then Tracy talked about joint ownerships and the joys and the pitfalls of that. That is another probate avoidance, and it can be viewed as a will alternative. We talked about guardianship and conservatorship, probate court involvement, and then any more questions? Yes.
On the transfer of death deed, or could you do that through the revocable trust that you just, that the transfers over and it's a different?
So if you had a revocable, so the question is, if you had a transfer on death deed, could you do that through the revocable trust? And if you had a revocable trust, you might actually deed the property into the revocable trust, and then the trust would determine who inherits the property, and it's not subject to probate, so it could transfer immediately. The trust, if the trust is the owner during your lifetime, the trust continues to be the insured during that administration time, so it can give you more flexibility. And if that beneficiary takes, the trustee deeds to the beneficiary, and the beneficiary wants to turn around and sell, it would be an easier path for a title company rather than a transfer on death deed. Okay, yes?
Is it always either a will and a trust? Or
that's a great question. That is a wonderful question. Is it always a will or a trust, or can you have both? And I would say that you can certainly have both. And in fact, if you have a trust, you still have a will, but very often your will becomes what's called a pour-over will. So it just takes whatever you have in your name and puts it into your trust, and the trust has the details in it. Instead of the will having all of the details about who inherits and who's in charge, it becomes a really plain document that just says, take whatever I have in my name, put it into my trust. And then the trust, that private document, covers the transfer. Okay. All right, yes?
Can you walk me through how you have a health power of attorney ahead of dementia?
Sure. So you can have a health power of attorney ahead of dementia. I have a healthcare power of attorney. It's part of my healthcare advance directive. Anybody over the age of 18 can create a healthcare advance directive. So there doesn't need to be a requirement that they're...
Do you write in that if someone, like my husband, sees dementia, how does that happen, that he takes over?
So with a healthcare advance directive, it can be effective as soon as you sign it. It can be effective only when your doctor says that you lack the ability to make your healthcare...
Write that in.
Yep, and it's generally, it's a checkbox.
So you can say, when my husband decides that I have dementia.
No, nope. It's not when your husband decides. It's when a medical professional or a judge decides.
Oh, you do have to do that?
Yes. If it's what's called a springing document, you have a professional who can spring forward and make it effective. In a trust, it is possible to have a disability panel that can determine disability. So you could have a panel of your family, and if a majority of them decided you could no longer make your own decisions, they could remove you as trustee and the successor would begin to serve. But that's not the case for a financial durable power of attorney or a healthcare advance directive. Okay, thank you so much.